Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has refused to extend the deadline of surrender by 11 convicts of the Bilkis Bano gang rape case. Earlier, a batch of petitions was filed by 10 of the convicts seeking more time to surrender, citing reasons such as family responsibilities, care of aged parents, harvesting of winter crops, and health conditions. While rejecting the petition, the Apex Court said that reasons cited in the application do not prevent them from complying with the January 8th order to surrender within 2 weeks. The Supreme Court has agreed to consider the early listing of a series of petitions in relation to marital rape. A bench led by CJ Diva Chandrachud has said that it will try to find a slot between the Constitution bench hearings. The matter was brought to the forefront by Senior Counsel Indra Jaisingh, who requested a fixed date for the case. Advocate Karuna Nundi, representing one of the petitioners, emphasized the urgency of addressing questions related to violence within intimate relationships. The CJI has said that the matter will be taken up between Constitution bench's cases. In 2022, the Supreme Court had issued an order to pose a trial involving a husband accused of raping his wife after the Karnataka High Court had upheld the charges against him. The Apex Court has agreed to examine an important legal question as to whether nuns and priests working as teachers in government-aided Christian missionary schools are entitled to income tax exemption. A bench comprising of Chief Justice Diva Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra took note of the submissions of the senior advocate Arvind Dattar that the petitions of several dioceses and congregations from Tamil Nadu and Kerala on the issue needed an urgent hearing. The bench agreed to consider listing of the petitions, which raised the issue whether the income of nuns and priests working as teachers can be subjected to income tax. In December 2014, the Income Tax Department asked the educational authorities to effect TDS, tax deducted source, from persons working as teachers. A division bench of the Apex Court has emphasized the need of a robust compensation framework for victims of hit-and-run accidents, coupled with measures to enhance public awareness and participation. The court expressed concern over the low utilization of the compensation of victims of hit-and-run motor accident scheme 2022, despite a significant numbers of reported hit-and-run accidents. It noted that there is a stark contrast between the high number of hit-and-run accidents reported in annual statistics and the low number of claims filed under the compensation scheme. The court recognized the pivotal role of the Standing Committee in periodically reviewing the scheme's functioning, making recommendations for amendments, and ensuring effective implementation. The court raised concern about the non-implementation of the scheme and directed the Standing Committee to identify the causes behind this and recommend corrective measures. Now let's have an overview of High Courts. The Allahabad High Court has held that unmarried daughters, regardless of their religious affiliations, have the right to obtain maintenance from parents irrespective of their age under the Domestic Violence Act. Dismissing a petition filed, Justice Jyotsna Sharma observed that there remains no doubt that an unmarried daughter, whether Hindu or Muslim, has a right to obtain maintenance irrespective of her age. This has made clear again that the courts must look for other laws applicable when the question pertains to the right to be maintained. However, where the issue does not pertain to mere maintenance, the independent rights are available to an aggrieved under the Section 20 of the Domestic Violence Act itself, the court said. The present petition was filed under the Protection of Women from Domestic Violence DV Act 2005 by the parents of 3 daughters, challenging the order of granting maintenance to them. The Kerala High Court has held that the witness testimony can be recorded in the presence of the accused's lawyer even if the court provides a one-day exemption from personal appearance. The court noted that special judge's technique for examining without the accused is not illegal and evidence can only be recorded when the accused's appearance is waived. The court did not conclude that sections 299 and 317 CrPC are the conclusive exemptions to section 273 and further stated that earlier decisions do not apply to the current case. The Andhra Pradesh High Court, while dismissing a petition seeking acceptance of evidence in the form of an affidavit, stated an accused in a check bounce case is not entitled to forward his evidence by way of an affidavit since Section 145(1) of the Negotiable Instrument Act 1882 entails only a complainant to tender evidence in such form. The court stated that an offence under Section 138 is said to have been committed only on the combined fulfillment of the ingredients in the main provision and eventualities in the proviso clauses, and the reading of Section 145(1) makes it clear that the provision entails a complainant to give his evidence on an affidavit and no mention is made with respect to the accused. The Himachal Pradesh High Court has observed that a criminal court cannot take cognizance of an allegation made against the notary touching the official purpose except upon a complaint made in writing. The court stated that the petitioner had attested the affidavits in the exercise of the functions conferred upon the Notaries Act. Therefore, the provisions of Section 13 will apply to the present case. When any allegation is made against the notary touching the official purpose, the criminal court cannot take cognizance except upon the complainant made in writing, the court said. The Madhya Pradesh High Court has reiterated that the amended Section 13 of the Prevention of Corruption Act would not obliterate the unamended Section 13(1)(d), as the same creates a vacuum in law and goes against the principle of rule of law. The court noted that accepting the concept of obliteration upon substitution of original provision by the unamended one would also free the past offenders of the crime committed under unamended Section 13(1)(d) of the application of Article 20 of the Constitution, and this can never be the intention of the law. The High Court of Jammu and Kashmir has held that there lies an opportunity to appeal in front of the Labour Commissioner competent to review the ex parte awards passed under the Workmen's Compensation Act of 1923. The court emphasized that Rule 41 of the Jammu-Kashmir Workmen's Compensation Rules allows setting aside ex parte decrees under certain conditions. The court partially allowed the petition, setting aside the Commissioner's order and directing the Commissioner to reconsider the application on its merit. Moving on to international news this week. Google is testing changes to some of its most important services, including Search, the Chrome browser, and its Android operating system ahead of the European Union's tough new antitrust rules coming into force in March, the company has announced. The changes come as a result of the bloc's Digital Market Act (DMA), a sweeping piece of legislation under which Google has been designated as a gatekeeper and given new rules of how it can operate important core platform service. China's industry ministry has issued draft guidelines for standardizing the artificial intelligence industry, it said in a statement posted on the ministry's website. The draft proposes to form more than 50 national and industry-wide standards for AI by 2026. It also said China aimed to participate in forming more than 20 international standards for AI by that time. Apple watches capable of reading blood oxygen levels cannot be imported into the US while Apple challenges a government decision that the device infringe on patents, a federal appeals court has ruled. Imports of the smartwatches equipped with blood oximeters were previously allowed while the appeals wound its way through court. In the end, we have miscellaneous news. Trouble mounted for a plaintiff in a case after she was overheard abusing the court during a video conferencing hearing and got served a contempt notice. The Delhi High Court has initiated a suo motu criminal contempt of court case against an Australia-based Indian woman for using derogatory language against a judge when the proceedings were going on virtually. Emphasizing that the right to broadcast live events, that is, live rights, is not copyright and thus any payment made to it cannot be said to be chargeable to tax as royalty under Section 916 of the Income Tax Act 1961, the Delhi ITAT holds SSE not in default for failure to deduct tax at source on foreign remittance towards acquisition of the rights to broadcast live events. The tribunal observed that the broadcasting live events does not amount to a work in which copyright subsists, indicating that the right to broadcast live events, that is, live rights, is not copyright and consequently, the payment made to it cannot be deemed to be liable as tax as royalty under Section 916. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.